Now, if you're resident in Spain, the applicable law will be the Spanish. And here we go. Here we open the can of worms. The Spanish, unfortunately, is not treated the same freedom on wheels as the British or the Americans. For example, I cannot leave everything to my wife. 2/3 must go to my children.
This is BayRadio.
Delighted to welcome back. I always say that, and we're very grateful as well, because I know it's a whole to-do for you to get here of a morning, Ignacio, from Pellicer Heredia.
Yeah.
Dropping the kids off at school, but not nearby here either. And then I don't think of getting stuck in traffic as much over here, because a lot of us, we live quite close to where we work, and maybe not on the motorway every day, but it's a similar thing to maybe back in the UK.
Yeah, well, good morning, Moody. Yes, I've been a bit stressed this morning because we got a traffic jam in the A7. And after dropping the kids to school in Alicante, it was impossible to keep moving. But I made it, so that's good. I'm back here.
Exactly, and this is where we'd normally go on anyway, so not late or anything like that. Now, where do we start then? Because we've covered a lot about the visas and residency. That kind of took up the first couple of 3 sessions that we did. We're going to start with something different today because, being legal folk, should we talk about wills? Because it's a big thing over here, particularly if you've moved over. Things may be different. You may need a Spanish and an English one. So where do we start?
Good. I could just start giving some piece of advice for people who are resident or non-resident, but they've got property or assets in Spain. Okay. Is it obligatory, Moody, to make a will in Spain? No, you're not obliged. Okay. Do I recommend it? Yes. As long as you have assets in Spain, yes. It doesn't matter whether you're resident or non-resident, okay? Because if the inevitable happens, then you need to think how they're going to sort all these problems out and how they're going to transfer all these assets to your beneficiaries. So I will start saying, please do check if you have a will, if the will is according to your wishes, because the wills can be updated. And a lot of questions Moody asked me if it did affect Brexit to wills.
I was going to ask you that, yeah.
And then actually the answer is no, because the situation for people to understand, if you're resident in Spain, you're British, or any other national country that you are, you've got the option to choose the national law, which it will be, in this case, the British law, or if you say nothing, it will be your residency law, which is the Spanish. If you live in Spain, it will be the Spanish, and there is a treaty. UK never signed this treaty, but it doesn't really matter because if you're resident in Spain, it affects residents.
I see.
Okay? So people get confused about Brexit with this, but the answer is if you have a will and you made the option and chose the applicable law, okay, you should be fine. Now, I always recommend to review the wills just in case, because some changes come. And I will tell you later on some tips about what do I think is best, because sometimes we do international wills. Some people say, I do have assets abroad. And depending on the situation, I recommend them to do an international will, which we've done a lot of them. Obviously, if it's too complex, it's better to have one in the home country and one here. Yeah. But if we're talking about probably bank accounts abroad, simple things, you could just save and just do one here in Spanish, in English, translate it, and fully legal. And that will avoid you flying back over there and doing just a will for little things. You know?
So you can do an English will over here?
Yes. What we've been doing here so far, the most, I will say, advisable will that we've done is the international will. We do the Spanish and the English in 2 columns, in 2 languages. As well, we send it, we need to legalize it here at the notary office. We always include the will. It will really depend, because some people might say, well, some wills are straightforward, some wills are complex, but I always try to mention specific clauses to avoid problems in the future. And we always put as well clauses of executors, so the client giving us instructions what to do in the future in case the inevitable happens, what would you like? And then we need to always focus on tax planning. It's important to know if I were to pass away today, what would I leave? How would it affect? And we could do inheritance tax planning. You know, and that's important as well.
Of course, there is that,
So one side we mentioned a clause about executors, which is very good. The way they want to do it. Now, if I want you to sell the property, for example, one clause we do mention and is popular within our wills, and we've been writing, I don't know, I couldn't give you a number, probably 1,000 wills already. One popular clause I always mention is, in case there is several beneficiaries, we just say here, it goes to them unless one of the beneficiaries do not want the property. If they do not want the property, the client already gives us instructions to sell the property and just split the money between the beneficiaries. Why? Because let's say some people have some issues. One wants to stay here, one just wants the money. You don't want to end up in a court case, you know. And
no, sure.
And going through a court case takes a long time, it costs money, and I highly recommend not to do it. So putting the right clauses in the wills is important.
Do you have to do that bit? You know, we see in the movies and TV series where the family gather and you have to read out the will, you know, everything, who gets what. Do you do that bit?
No. Basically, the process, what happens here is the client just comes up to our office, okay, just appoints the beneficiaries. We advise whether it's better or not. I will mention later on that some people just leave it split between 6, 7, 8 people. That's a lot of work for the future and a lot of people to say, because you need to get power of attorney from all of them. And normally we deal with the beneficiaries abroad, they grant power of attorney. But the problem I find, Moody, here is putting everybody agreeing to something, you know, agreeing to get the power of attorney. Some people do not even have a passport in the UK. I'm dealing actually with a complex inheritance where is children, grandchildren. You could imagine to organise all that.
Yes. I mean, again, unless TV and movies have lied to me, the family falls out over who's got what and, you know, say, I deserve that. I spent more time with them than you. And but that's a real thing, though, is it? It can come to that sometimes.
It is. The thing is, probably they don't do it in front of the solicitor, you know.
Right.
You just listen that story later on saying that they've fallen apart and one wants to sell, the other one doesn't want to. One gets into the property. You know, that's why it's important to live. Or I always say to my clients, just let's do the formal will, okay, the best way we could do it for everybody, and then you later on leave me a note how you want it, because certain things you don't need to even mention in the will, you know, it's just instructions to the executor, what to do, what not to do, etc., etc. And so yes, we've been very busy with these sort of things, and I highly recommend people to think twice when they do the will. 2 things important: tax planning, how to, depending on the value of the assets, we could just have a better simulation, a scenario. And the second, if you're going to leave to the grandchildren and all these things and they're not legal age, it might be better probably in some cases to make legacies, you know, just money. Because the fact of them getting power of attorney and then having the passport, because to get a power of attorney here, to get the NI number, Moody, they will request me a passport. Mm-hmm. So some people in the UK didn't need to travel and they never had so they need to go with the aggravation of getting the passport. Let's say, and I'm dealing with one case like this. It's 9 people involved.
Oh, wow.
Probably 6 of them or 5 of them are children. And then you need to sell the property. So unless they could organise a power of attorney for me to start dealing, I'm a bit just tied up. And this is what sometimes some people even say, Moody, I will leave everything to my son or my sister, somebody, and he will split these assets along with his beneficiaries. You know, it's like more informal way of doing it. But legacies are good because you could say, I leave X amount of pounds to this one and then X of that. And when there is talking about money, it's easy to make bank transfers, you know?
Yeah, sure. And they can get it straight away. Or is there a way of doing it that they get it when they're 18 or something like that?
Yes, I've got some clauses as well where people say, Ignacio, I just want you to withhold it, or just want their son to withhold it until they're legal age and they go to university. certain things like that, but we always need to think what is the best for your situation, and sometimes that's why I'm saying here, Moody, it's good people to have always, my first advice, you need a will because it will be helpful. But between all the wills, if you could do the best tax efficient and the best distribution between the beneficiaries, the better for you and for everybody, actually.
And as far as the tax planning goes, what about the inheritance tax side of things? I think we've touched on this before because it's different in Spain, isn't it? And when you talked about someone saying they don't want the property, we have had that happen.
Yes.
Where it's not been worth their while because you're paying the taxes on it.
Yes. I've got a case as well where some people are saying, I remember one person made a will to nephews, actually, and they don't want it because they say, I don't want to inherit any debts. And here we go. That's another issue as well, because you need to renounce or waive officially the inheritance,
Sure.
But with regards to inheritance tax, Moody, the situation is not as good as it used to be. It used to be 99% off discount on the tax. Now you have 100,000 euros between family. That means husband, wife, and children. That's the first grade on the scale. You have 100. On the main property, you have up to 156,000 euros. But on that allowance, 95% off the tax. And then after that, you have a 50% discount on whatever tax you need to pay on inheritance tax.
I see. Okay.
So here I'm telling you, depending on the amount of money you're leaving, probably tax planning might be, okay, I've got 3 children. It might be good to split it between 3 because then I use all the allowances. I use 100 and the 156,
okay.
you see?
Yeah.
But so that's why it's important to discuss the wills and always look ahead and see what could happen, and what tax could you... I mean, we never know in the future what kind of tax we're going to pay because the law has been changing and it will be changing. I hope one day it will be zero tax, as it always used to be in the old days. It depends on regions as well, Moody. Now in Comunidad Valenciana, we've got these allowances. Andalucía, they made a bigger allowance. In the old days, Murcia was similar. They remove it with a credit crunch. They remove it and they remove all the allowance, and that was terrible. And people didn't complete. You will see people not even completing the inheritance because they couldn't pay. So they'll say, well, I'm not going to sell it. You're blocked, basically. At the end of the day, you cannot touch the money in the bank. You cannot do it, but they just use the length of time, so it will expire. Okay?
Yeah,
so
it was always a thing I find out here through talking to people like yourself that we had on, that you have to pay the taxes up front almost before you...
Right.
Or very early on, anyway, compared to the UK.
Yeah, that's a good point, Moody, and I think it's good to clarify here. If the inevitable happens, then what the bank does is as soon as they know, they block it because they don't know who's the beneficiary. So what I normally recommend is go and speak to your lawyer, show him the will in good faith, and obviously he will tell you how to move forward. I always leave the bank, informing the bank for the latest so you can have enough finance to leave, and then depending on the amount of money is left, because there is just like a protection measure they do to see whether somebody else is beneficiary. But I have in a lot of cases where 50% is husband, 50% the wife, and then as soon as they know, they block 50%, okay? Well, I will normally recommend them to go and speak to the solicitor, try to put everything in motion, and then leave the certificate of that for the very last minute. So once you ask for the certificate, you show him the death certificate to the bank, they block it, but probably if you complete the following week, they will unblock it very, very quick.
Right.
So some people are scared of that, but if you do it properly, you shouldn't have any problem. Right?
All right. Yeah, and I mean, the thing with wills, every time you do one, it's going to be different. They're all different. There's all the little various different things, and that's where you come in, and you can maybe advise people on their particular situation. So it's not a one will fits all thing.
No. What is probably good for me is not good for the others, and the other way around. And but normal cases here will be a lot of clients. Moody asked me, Ignacio, what about the NI number? Yes. I said, no worry. At the end of the day, the beneficiaries will have to grant power of attorney, and I could get it for them. You know, the NI number is not an issue. I will be more concerned of organising power of attorney from them onto the executor, the solicitor, etc., because otherwise it cannot process. And the other thing and advice I will tell the audience here, it will be try to have the will very, very well organised. Why? Because you need to know a possible scenario and how it's going to move. For example, as I said, grandchildren, children, nephews, all these things. You need to know how we're going to gather all these documents to put in their name, how easy it's going to be. You know, me particularly, I will say children, just legacy or money. You know, that will be easy.
That's probably what they want as
you
well.
know, yeah. Just having the property into joint names with a lot of beneficiaries is not ideal. It's not ideal because they all need to agree. Well, once you are the executor, you've got more power to make a decision, you know. But obviously, that's why I mentioned the clauses here, Moody. If one doesn't want the property, just only I need one, so I am allowed to sell the property and then split the money, you know, because otherwise they will do it through the courts. Yeah,
I guess one or two of the cases you've been talking about where you've said they don't want it, it may be that the property's not paid off yet, the mortgage isn't paid off. Well, when we think of wills, we think of an older person that owns the property, they're not still paying for it, but there will be cases where there's still a mortgage on it.
Yes, and normally it is very likely, Moody, when you have a mortgage, there is a life insurance.
Yeah, sure.
So it's very likely. I mean, especially now, probably after 2008, I think. Before, probably I've seen cases where there is no mortgage, or they wouldn't insure because of the age unless your children was on the deeds. And probably, you know, in the old days, they did accept a lot of things that probably now they don't. The life insurance will take place. So let's put it this way. I have a mortgage. I have life insurance. We need to just work out how much is the insurance and if he's going to pay it off.
Pay it off, yeah.
You know, because probably the property is worth much more.
Sure. I was just asking about what's the main sort of thing that you do, and it is very kind of sometimes seasonal. You got visas particularly hot at the moment. And the website, the special website, visaspain.today, will tell you what you need to know, particularly about the sort of golden visa and non-lucrative visa is what I've learned about. So, but all the details through the website, alicantelawyers.es is the easiest way to do it, to remember. And go to the blog, because kept right up to date, all the useful stuff. There will be bits about wills in there as well, which we've started talking about today. I think there's a bit more to cover. I just asked you, I said, you must get people saying, I'm too young to make a will. You don't even think about it till you're, much older.
Yes, actually, Moody, a lot of people say that. And I have young clients as well. That when you start talking about wills, probably it's a bit of a shock because you don't plan these things yet, do you?
No,
when you're young.
No, I don't plan to go just yet.
Yeah. But let me tell you some points here as well. Why I know it's uncomfortable. Probably you don't want just neither to spend the time, neither the money. But I think it's peace of mind. We all have insurance at one point. And to be honest, this is the insurance that all your assets goes to the person that you wish them to have. And we don't know when we're all going to go. So it could happen suddenly. And the way I say is, okay, I don't have any assets now today, but I'm young. But I might have it tomorrow, or I might inherit something from my family. And all these things happen. All these, like you say on the movies, you could see these things happening. But I have a lot of cases where, unfortunately, something happens. And now, the situation I'm going to explain, Moody, if you don't have a will, then the first thing I'm going to try to identify is your nationality and the law, applicable law. Now, if you're resident in Spain, the applicable law will be the Spanish. And here we go. Here we open the can of worms. The Spanish, unfortunately, is not treated the same freedom on wills as the British or the Americans. We are limited. You could only leave a certain amount to the third parties. For example, I cannot leave everything to my wife. 2/3 must go to my children.
Oh.
Yes. So this is the limitation, and it's very common and sensible people sending, saying, Ignacio, I'm going to leave everything to my wife, or my wife is going to leave everything to me. That's completely possible if your will states that you're using the national law, which allows you, which is British law, and allows you, even though. Now, if you are a resident and you didn't say anything, which we call it ab interstate is not will, left, okay? Then you have this issue. Now you have no control at all of your assets, and it goes to the legal heirs. Now, if you don't have children, it will go to your parents. If you don't have parents, it will go to your brothers and sisters. Then if you don't have brothers and sisters, you go to the nephews. You don't have nephews, it will go to the children's. And if not, it goes to the state. Now, going all this, trying to prove all these things, and I need to get birth certificates of everybody. Yeah. You could imagine having all these people, birth certificates, trying to prove the triangle.
Yeah.
So no. So that's why I said, if I know it's never a good time to do it, but I always say to clients, do it at least once in your life. Do it once. Then you could change it. You could update it. Some clients are doing two wills, one international will, and the other one is the one that donation of the bodies and the and living instructions to disconnect you in case of painful illness.
Yes. Now, this is a thing, because you mentioned it to me. This is not me knowing all this stuff, but I do know about the law in Spain about euthanasia.
Yes.
Coming in. Okay.
It's being approved very, very recent. And I already had an inquiry, and that they want to put it in the will, And the way we do it is two ways. One is the will, what we call it the civil will, which is about financial and assets. The second thing, now, is important as well. I forgot to mention the life insurance and the policies. Some people, and it's important they tell their solicitor, they've got some insurance with special beneficiaries. So in the will that we normally draw up, we include even policies. So this existing will remove anything in the past. For example, I had a case, we didn't know one client had some funds with a special beneficiaries clause. That Ley del Seguro with the insurance law says that you could specifically appoint somebody, even though you have a will saying everything goes to your children. It's important you disclose this information with your solicitor, because, and what I do in the wills, I always ask the client, do you want me to include here everything? Means everything. So and this will change the policies you have in the past that probably you don't remember, and it might go to somebody else. Yeah.
And also in there, you can designate the power of attorney, can't you? If you become incapacitated, yes, as it were, lose your faculties.
Right. So we said we've got the civil will, which is one side about assets, international will or national will. And then we have the what we call vital will. We call it in Spain testamento vital, right? It's just giving instructions to the social security or doctors on the way you want to be treated. For example, I don't want you to give me any extra medicines to maintain artificially my life, which is not the euthanasia. It was what the old version we had is like, let me die with dignity.
Yeah, I think they say a do not resuscitate. It's like the equivalent to that, I suppose, in a will. Yeah.
Correct. And so we're doing two. One that is registered with the Social Security, and then you can mention there as well. And that's a time to mention that you want to use all the rights that the euthanasia law gives you, which is a bit extended, Moody. I mean, in the old days, it was, okay, don't artificially keep me alive. And the other one might be even removing, it's just all these, but the bottom line is you have full control of what you want to do. That's the bottom line. And now it's possible. And you could even mention in the will, So that's something good. And you mentioned as well, Moody, something about power of attorney.
Yeah.
That's very good, what you just said, because I recommend clients, especially elderly people, at least to grant power of attorney, husband to wife, wife to husband, okay? Because that is going to make life probably easier dealing with financial, dealing with assets. There is a type of power of attorney as well, which is preventivo, which is preventive, which even authorize your husband, your wife, even your lawyer to make decisions at the hospital when you're not capable to make decisions. Okay, that's what we call poder preventivo, and this extended version. Okay. Now, power of attorneys can be organized here in Spain, or we could even organize it at the consulate in the UK, the Spanish consulate around the world, or we could have it signed as well, this power of attorney, signed before a public notary in the UK, seal, apostille, translate it, send it back here. So there are ways to do all these things, and especially people which there are limited with mobility and things like that, I think is very useful as long as you have trust on the people that you're going to rely the power of attorney, and you could always cancel and revoke that power of attorney.
Right.
So there is no problem for you to go back to the same place and revoke it. And there is a registry of power of attorney, which will now is being shared between the administration of justice and the Law Society of the Notaries, where they could check whether your power of attorney is still valid or not.
Okay.
So it's very, very good, protective. And the registries work very well. And for wills, Moody, we didn't touch this subject, but the Spanish system I consider is very protective, because once you make a will, your will is private, is at the notary office where you have to just sign. And the information that you just did sign this date, not the content, is sent to the last will registry in Madrid.
Yes.
So with the death certificate, you just make an application, and the registry will say where is the last notary office where the late person signed the will. And that's how you find out where is the will. And you need to prove that you are a beneficiary or family. And then you go there, make the application, and get it. So the registry is very good. I think in the UK they don't use that much registry, as according to my clients. They do wills, but they don't register. You could register, but it's not that. And I think here is peace of mind.
So fairly efficient over here then.
Yes.
Just mentioning the euthanasia thing again, I don't to dwell on all of this, but it's a law that's come in this year. Do you come into that as lawyers? Do they need to go through you? Or
No. No. At the end of the day, I didn't study the whole law yet. It was passed recently.
Yeah.
And the people been claiming about this, but basically it's like the right to die, basically. And they need to... I think they will have to remove, obviously, the criminal code, obviously.
Yes, and I think that there's quite a few checks. You have to apply twice for it, a few weeks apart. So it's like, I saw it as the equivalent of when they're buying a gun in the States. You have this cooling off period, because you could apply and then maybe change your mind, but you confirm it again a few weeks later, and it has to go to a committee, and... a second sort of doctor as well, a second opinion.
Yes.
And that sort of thing. So it's quite a process.
It's
not
process.
just as simple as saying, I want to...
No. But at least is
all the checks are there, in place.
Yes, of course, because otherwise Moody will be so easy to, he's a bit dangerous, probably.
Yes.
Yeah.
But
yes, with all the checks, but you still could express that you don't want to carry on the way you are.
And that can go in your will. Yeah.
Yes. Yeah. And now you could go in your will... which is the Social Security will, which is good because it's connected with the Social Security. But it's good to keep both. If you want to have these things, I always recommend to have these two type of wills: the assets one, and the same day you do the vital will, which is more about health. Okay.
And of course, you can, if you've got assets in Spain and the UK, you can do the international will.
Yes.
One for each country, that sort of thing.
Yeah, we could do the international will, but is very depending on the specific asset situation. Because, for example, somebody who's got a lot of assets in the UK, it will make it sensible to have one will in the UK and one for Spain, one for the UK, not to make things more complex. I always try to make things simple. Keep it simple, and then
there's the tax efficiency side of things, of course, obviously.
Yes.
Whatever's best there.
You could use a dual taxation treaty between Spain and the UK, and even for inheritance tax. Okay, so but yes, it's quite a world about the inheritance tax, where the late person was, where are the beneficiaries, where are the assets, are the three questions we all need to make the puzzle of what. Let's say you pass away, you're resident in Spain, but all the assets are in the UK, the beneficiaries are in the UK. It's different treatment, and sometimes it's tax efficient.
Yeah. Well, for anyone listening, if that all sounds quite complicated, it probably can be, but this is what you do every day. So that's why people come and talk to you and get it sorted. So I'm sure you'd be able to help them out. Thank you ever so much. We're just about out of time.
Okay.
Anything else we needed to add? Well, you're here. Just a reminder of the website, alicantelawyers.es. As I say, particularly keep an eye on that. You can go to any language on there as well. English, Spanish, Dutch, Russian, whatever. And the blog. There's plenty of useful articles on there. All right. Well, we thank you for your time, as always.
Thank you, Moody.
Hopefully see you in a couple of weeks.
We'll see you soon.